Oh, no mai, haiki mai ki tēnei hui. Welcome back everyone to the conference and welcome to this session called Alan Borum Tako Ingoa. My name's Alan Borum. I'm the Deputy Chief Executive for Oranga Tamariki, the Ministry of Children here in Aotearoa, New Zealand. Again, no ngā mihi nui ki a koutou katoa. Warm greetings from me, as I said in my original message, to all of you. And if I could just acknowledge the mana whenua in Tamaki Makaurau, Auckland, Ngāti Whātua o Ōrāki, as well as all the organisers, including Auckland University and all the AYJC members that have been involved in putting this conference together. And I also want to take the opportunity to acknowledge all those that have submitted abstracts and have been presenting, and our keynote speakers. The commitment and effort for everyone to do this is not underestimated. I do understand that there were some technical difficulties with 3 of the sessions right at the start, as we were just getting things going. I think it was arranged by the other presenters, so everyone had to watch their ones. But I can tell you won't miss anything out. Those sessions have been recorded as we speak and they'll be uploaded this evening, so you won't miss anything at all. We will have until 1:50 p.m. with our keynote speaker, and we'll keep to that time frame. And you'll be able to see his presentation. That'll be recorded and uploaded at the end of the day. At the end of his presentation, we'll have a short digital performance. This blends some poetry from young people at Te Punawai, one of our youth justice residences in Christchurch, and Match, a provider in the Kapiti Coast. For those of you who are joining for the first time, if you haven't had some instructions on the platform how to use it, you can enlarge the screen by clicking on the arrows in the top right corner. And there's some session information about the sessions is all there for you to see. There is a live Q&A. I really welcome you to use that as our keynote speaker is talking to you, and we'll get into those at the end of his session. There's also a discussion forum where you can chat with each other as well. And so I'm delighted, and it's my privilege to introduce Judge Walker as our first keynote speaker. His Honour Judge Walker was appointed to the role of Principal Youth Court Judge for Aotearoa, New Zealand in 2016. He's born in Belfast, Ireland, and graduated with an LLB from Victoria University in Wellington, and was admitted to the bar in 1976, so incredibly experienced. He's practised both in Palmerston North and in Wellington, and then became a district court judge in 1994. Judge Walker's been absolutely instrumental in the development of court-assisted interventions for alcohol and other drug dependency, including the establishment of the Youth Drug Court in Christchurch and Adult Drug Courts in Auckland. And during his time as a resident judge for the Porirua District Court, Judge Walker encouraged better engagement between the court and the community, mainstreaming the community justice centre model and developing a solution-focused judging approach. And in recent years, he's been leading the development of district court responses to family violence. And a focus for him has been the implementation of a young adult list pilot, which is a court for 18 to 25-year-olds, taking quite a youth court approach to dealing with them in the adult court. And he's looking to implement those into other lists across New Zealand. So from personal experience, and I work very closely with Judge Walker, I can tell you he is absolutely a champion in the courts to better understand and provide services to young people, especially those with neurodiversity challenges. He doesn't see 18 years old as some kind of watershed, but looks for the opportunities in the adult courts to help them too. And he's a system leader for justice. And a good example for us recently has been how he's been able to bring all the youth court agencies together so we could pivot really smartly in response to the big challenges we've had around COVID. Again, delighted, and it's my privilege to introduce to you Principal Youth Court Judge John Walker. Over to you, John.
Thank you, Alan. Ena mana, ena reo, ena karangatanga mahi, tēnā koutou, tēnā koutou, tēnā koutou katoa. Greetings to you all. To our Australian colleagues, it's appropriate that I acknowledge and pay respects to the traditional owners and custodians of the lands from which you join the conference today. I pay my respects to their elders, past and present, and to their emerging leaders. Thank you for the invitation to speak to you today, and thank you, Alan, for that kind introduction. The importance of an interdisciplinary team approach in youth justice cannot be overstated. As it is in any solution-focused approach, which I think is an appropriate approach in youth justice, it's not just the judge, it's not just the social workers, not just the police, the lawyers. It's everybody working together to a common end, endeavouring to deliver interventions to our young people to disrupt the trajectory that they might be on, leading to more and more youth justice and adult justice responses for some of our young people. Playing interference is really what we should be about. They are multifaceted problems that beset our young people and their family, and the responses need to be multifaceted as well. Can I start by giving you an introduction of our youth justice system here in Aotearoa, New Zealand? As we know that system today, it's still relatively young, with its inception in 1989, just over 30 years ago. Prior to the new legislation in 1989, known then as the Children, Young Persons and Their Families Act, known now as the Orana Tamariki Act, young people, and young Māori in particular, were being locked up at extremely high rates in various forms of detention and being removed from their whānau and their communities in that process. In 1989, there was a ministerial advisory committee formed in New Zealand at the request of the Minister for Social Welfare to look at a Māori perspective for the department, the forerunner of Orana Tamariki in New Zealand. And a report was released entitled Poa Te Atatu, or Daybreak, a new beginning, a new recipe for dealing with youth justice issues. And that report resulted in the Children, Young Persons and Their Families Act, and through that act, the creation of the Youth Court as we know it today. The act had an immediate effect. In the year prior to the introduction of the new legislation and the setting up of the Youth Court, there were nearly 10,000 young people in the youth justice system in New Zealand. The year after the Act was passed, the number dropped to 2,000. And it's more than halved again, with less than 800 people in total in the youth courts of New Zealand. The drop in numbers was enabled by the foundational principles of the 1989 Act. Diversion away from formal court settings was a central pillar of the youth justice system and continues to be so. One of the guiding principles in the legislation is that criminal proceedings are to be brought as a matter of last resort. And the legislation creates many hurdles to be jumped before a case can come to court. Restrictions on arrest, directions that police officers consider before bringing a case to court, whether it can be dealt with in an alternative way. The result is that today, around 75% of all apprehensions do not come anywhere near the court, but are dealt with in some alternative way by the specialist section of police youth aid. And the work that those youth aid officers do is invaluable in this regard. We know from all of the research that bringing young people who are in conflict with the law into the formal court setting at an early age is a precursor to them remaining in the youth justice system. And so the more that can be done to keep them away from court, the better it is for everyone. Of course, there are some cases where that simply is not possible, where the level of offending and the seriousness of the offending is such that it just simply must come before the court. But the vast majority of cases can be dealt with in an alternative way. Other important principles include that measures for dealing with offending should address the underlying causes of the offending. In other words, solution-focused judging. It's well established in many of our specialist courts in Australia and New Zealand who are dealing with underlying causes of offending, that unless the underlying cause of offending is dealt with, then the offending behaviour will simply continue. Just to give one simple example, if a young person or adult is offending to feed a drug dependency, they focused on what they're going to have to do that day to be able to get their drug of choice. Often it involves acquisitive crime or dishonesty. It's quite clear in those cases that unless the dependency is got under control and is no longer a driver of conduct for that person, then the offending behaviour will simply continue, and we can't expect any different result. That's why we often see drug-dependent offenders cycling through the courts on a regular basis, escalating offending. And so not surprisingly, the Orana Tamariki Act requires everybody involved in the case to look for and endeavour to address the underlying causes of offending. So the Youth Court in New Zealand has been a solution-focused court since 1989, and drug courts around the world and other specialist courts have really come afterwards, although they too are solution-focused courts. The important principles also include that young people's rights, including those under the United Nations Convention on the Rights of the Child and the Convention on the Rights of Those with a Disability, are to be given effect to. Now, these recent amendments to the Act, specifically referring to those conventions and giving them voice and life in our system. It's not to say that we didn't pay attention to them before, but Parliament has clearly now indicated in recent amendments that these conventions have force. Other principles include that the young person's place within their family, whānau, iwi, and community should be recognised and supported. Although, as I mentioned, the number of children and young people in our youth court in New Zealand is low, the complexity that accompanies those young people is high. The young people who do come before the court are what are described as high risk and high needs individuals who have complex and challenging underlying issues. We already all know by now, I think, that young people, by virtue of their age, have an underdeveloped brain. The frontal lobe, the executive functioning, has not fully developed until mid-20s, sometimes later, if there has been exposure to trauma and exposure to alcohol and other drug dependency. So we start with that as a matter of universal application to the cohort that we are all focused on. And we need to add to that the very high prevalence of neurodisabilities in people who appear in the youth court, including dyslexia, autism, ADHD, fetal alcohol spectrum disorder, and acquired brain injury. Just dealing with acquired brain injury, the research in New Zealand establishes that somewhere between 45 and 50% of all people coming into our district court, our adult court, which would be similar to some of the magistrates' courts across Australia, but also includes the jurisdiction that would be exercised by your county courts. 50% of everybody coming in as a defendant has a history of traumatic brain injury, an extremely high and worrying figure. So we have an underdeveloped brain, a brain affected trauma and injury, together with a high prevalence of other neurodisabilities. A soon-to-be-released research project from the University of Otago through the Donald Beasley Institute and in cooperation with the University of Sheffield in England has found that 37% of young people up to the age of 24 years in the criminal justice system have a formally recorded type of neurodisability, compared with 27% in the general population. But the true prevalence is likely to be substantially higher, as a number of neurodiversities or disabilities will not be identified or formally recorded in systems. Other studies have found that about 60 to 90% of young people in custody have a communication disorder, compared to between 1 and 7% in the general population. An Australian study of young people in custody has found that more than 1/3 were diagnosed with fetal alcohol spectrum disorder, or FASD or FASD, all previously undetected. Although there has not yet been a prevalent study of FASD in New Zealand, there is no reason to think that the figures would be any lower. Studies into 42 international prisons found that 30% of young offenders had clinically diagnosable ADHD. The prevalence levels are such in our youth courts that even if we don't have formal diagnosis, the safe course is for us to proceed on the basis that it is more likely than not that the person in our courtroom has a neurodisability or other challenge to their participation in the case which is about them. If we proceed on that basis and make accommodations for that, then if we are dealing with somebody who has no challenges at all, which is unlikely, we do no harm. But unless we take steps to accommodate what is more likely than not to be the case, then we can do great harm. Many of you will have heard of the term therapeutic jurisprudence. It came out of studies by David Wexler, a lawyer, and Bruce Winnick, a psychiatrist in New York. That term arose from their view that courts could be both therapeutic and anti-therapeutic. They could do good, and they were also capable of doing real harm. Knowing who we are dealing with and the challenges that beset them is important if we are to do no harm in that regard. There's also an increasing prevalence of young people in court with early onset of mental illness, alcohol and other drug dependency, often very well established by the time these young people come into the youth court, and exposure to trauma, including trauma resulting from being exposed to family harm. Whether that is witnessing it, hearing it, knowing about it, feeling the effects of it in the home with the heightened tensions that will surround a family where family harm is prevalent. Can I talk to you about the New Zealand situation? In 2020, there were 165,000 family violence call-outs by police. Children were present at about 2/3 of those call-outs. When we take into account that only about 20% of family violence is ever reported, it's clear that there are a very large number of children out in the New Zealand community who are exposed to the trauma of family harm. I often envisage the children in their bedrooms when police are called to a family harm incident. They hear all that, they hear the police arrive in the middle of the night, and I envisage young children watching around the door jamb as to what is happening in their home, a place where they ought to be safe. We know that that is deeply traumatic for young people to be exposed to harm in this way, whether they are touched or not. Witnessing it is enough. Around 80% of child and youth offenders in New Zealand have evidence of family in their home. In the year ended June 2021, in our family court, there were 6,000 protection order applications filed. That is, where somebody is seeking protection from ongoing violence. 60% of those applications included children. These are the silent victims of family harm. A great deal of our system concentrates on the primary victim and on the perpetrator of violence. But we store up a huge problem for our future if we don't pay sufficient attention to the silent victims. Exposure to family harm, I used to always think, was what led to learned behavior in later life. But this is how the cycle of family harm would be perpetuated. Children just regarding violence in the home as normal. Young girls seeing violence from a partner as being normal. And all of that is true still. But we also know that the trauma that is suffered has an effect on the young person's brain development, as well as their learned behaviors. So it's like a double whammy effect that we need to be paying real attention to when you look at these figures. The young people we see in our youth court are often not in education. Almost half of the young people who offend are not enrolled in school or have been excluded from school or simply not attending and lost to the system. The reason why they are not in school is highly important to identify. and may in fact be related to one or more of the issues, challenges which I have already discussed. For us just to say that they need to get back into school and everything will be okay is just too simplistic. We need to know why they are out of school. Just as we need to always be asking when we are in a youth court, why is this offending occurring? You know, as a judge, it's quite simple and straightforward to look at a summary of the facts that are alleged by the prosecution and understand the offence, understand the assault, understand the theft or the aggravated robbery. That's the easy bit. Understanding why it happened is the challenge. And going back to what I said about solution-focused judging, unless we can understand why the case is before the court, then we have very little chance of disrupting the trajectory of that young person's life into more offending. We see in New Zealand youth courts a disproportionate number of Māori and Pacifica young people coming through our system. Around 60% of all young people in the youth court are Māori, compared to only 14% of the general population. From all ethnicities in our court, we often see disconnection from culture. Young people with no sense of where they belong, where they have come from, and what their place is in the world. They drift. To see what a future might be must be very difficult, if not impossible, if you don't know where you've come from and where you are and your existing place in the world. So those are the headline issues that I see in our youth court in New Zealand. To what extent it applies to your courts that you're involved in Australia will be a matter, of course, for you in Australia to know. I suspect that there is not much difference. So in response to these issues, the Youth Court has had to adapt and respond. As I said, the Youth Court is based on a solution-focused approach aimed at addressing the underlying causes of offending. You can see this in the statutory provisions requiring judges to engage with young people and to do what is possible to encourage and assist them to participate. Participation is something that young people in court often struggle with. Neurodisabilities can greatly affect the ability to participate and be barriers to engagement. But even without the existence of neurodisabilities, the courtroom's a strange place, unfamiliar to most, a frightening environment. And it can make it very difficult for young people and their whānau and anybody else connected with the case, including victims, to engage. I once had a young person tell me outside of the courtroom when I was interviewing some young people to understand their experience of court, that he couldn't hear what was being said in court because his heart was beating so loudly. The language that we use in court is also often a barrier to participation. How often do we hear in our courts, including youth courts, words like remand, adjourn, bail conditions, We have bail conditions imposed that are difficult to understand. You are not to associate with so-and-so and so-and-so. You are not to consume alcohol or other drugs. You are to reside at such and such an address. These are largely meaningless to anybody coming into our courtrooms, apart from the lawyers and those of us who are familiar with the terminology. Much like anything, the law as a profession is full of jargon. But young people need to participate in the case which is about them. We need to be able to engage our young people in the process so as to be able to engage them in effective interventions. They won't do that if they sense that it's been done to them. They don't understand what's happening. We need to carry them with us to be effective. Changing our language to plain language is a challenge for all of us. There are several steps that we have taken in the Youth Court to attempt to remove the barriers to engagement and make the court a more welcoming place for everybody. One of the most important things is to adapt the language and to make it simple and to avoid legal and other jargon. I interviewed a young man at Rimataka Prison just north of Wellington in a youth unit for 18 to 25-year-olds when I was seeing how that cohort experienced courts. One of them said to me, in relation to the words used in the court, "It would be good if you just talked normal. It would be good if you just talked normal." It's not too much to ask when your liberty is at stake or your guilt or innocence is at stake. So we must strive to just talk normal. We have the ability in New Zealand to use specialist forensic speech therapists as communication assistants, and we appoint those people in our youth courts to assist with those who have particular difficulties in court proceedings. However, there's often more that we can do as a court before we have to take that step, such as ensuring simple language, taking appropriate breaks, and continually checking on the level of understanding. We adapt the physical layout of the court to make the space less intimidating. We try and sit in a horseshoe layout with the judge on the same level as the young person. Te Koti Rangatahi courts were established in 2008 in response to the overrepresentation of young Māori in the youth justice system. These are courts which are youth courts, but they move from the setting within a court building onto marae, the centre of Māori community life. We changed the location of the court proceedings to accommodate this group of young people and their whānau, to bring them into more connection with their communities and to make the setting a setting where there can be full participation. Today, we have 16 Te Koti Rangatahi courts across New Zealand and 2 Pasifika courts, based on the same model, basing themselves in church halls, the centre of Pasifika communities. These courts help to meet the needs of young people disconnected from their culture. Cultural elements can be included also in the mainstream youth court, for example, through the use of Te Reo Māori, beginning court proceedings with a karakia or prayer, and inviting in court to speak and making it easy for them to do so. During the COVID lockdowns, when Te Koti Rangatahi courts have not been able to be safely held, the mainstream youth court has incorporated cultural elements to do the best we can in those circumstances. So the approach in the youth court has been influential over the wider justice system. There are two areas that the court has had particular influence on, and I'll talk to you about that today. The creation of the young adult list in Porirua District Court and Te Ao Marama, the stated vision for the district court to move from a place of darkness, Te Po, into an enlightened place, Te Ao Marama. The young adult list I set up in March 2020. It was created really in response to the following puzzle. The underlying issues affecting participation that I outlined earlier, the neurodisabilities, the brain injury, the exposure to trauma, don't have any expiry date. They are static factors that remain with people for life. Now, this means that when a young person enters the district court jurisdiction, they bring with them the disabilities, impacts of trauma, and the other issues they've had since childhood. They also have a still underdeveloped brain. When young people are in the youth court, they receive wraparound support and are assisted to participate in the way that I have talked about. A multidisciplinary team approach applies, and everybody is alert to the challenges that they may be facing. When they turn 18 and stand up in a district court, all of that support appears to drop away, and they are treated as if they are fully functioning adults suddenly, when demonstrably they are not. The young adult list was created in response to this problem and was predicated on the need to adapt the procedures in court to ensure procedural fairness for young adults who, by virtue of their age, have demonstrably different brain architecture than adults, and more likely than not, have disability. The young adult list means that all 18 to 25-year-olds in the charged with any offence are separated out into their own list on a set day. On that day, you might not think that you are in a district court. This is because, to a large degree, the courtroom in the young adult list reflects the youth court approach. There's a dedicated multidisciplinary team, all specially trained and working with young adults, including services such as bail support officers, adolescent specialist probation officers, adolescent mental health nurses, Māori, Pacific and ethnic services. There's increased information sharing between agencies and from the youth court and the family court. The information is gathered in those other jurisdictions, is often sealed and kept separate from the district court for no good reason, and a process of information into those courts is essential to providing a fair process. Plain language is used by everybody in the courtroom. The same group of judges are used to ensure consistency and to develop a relationship with the young adults and the judge. The architecture, the arrangement of the courtroom is changed to engender participation. This young adult list, as you can see from that description, really builds on the best practice of the youth court. It sets the standard for court participants being able to meaningfully participate in the case which is about them. Of course, the young adult list is still on a journey and much work is to be done in its development. The recent evaluation has confirmed that it is a step in the right direction. It came about because we have shown that the youth court approach is effective and it is applicable to adults as well as young people. Another way in which the Youth Court has influenced change is in the wider justice system. It's evident in the themes of youth justice and the lessons from the Youth Court which run through the vision for the District Court, Te Ao Manama. In November last year, Chief Judge of the District Court, Judge Hemi Tamonu, announced this vision for the District Court. At the heart of the vision is processes to ensure that all those who appear in court or come before the court, whether they be defendants, whānau, family, victims or others, are seen, heard, understood, and are able to meaningfully participate in the case which is about them. Much of this aspiration for how the courts could operate has the origin in the way the Youth Court already works. The Youth Court operated as a solution-focused court long before that term even came into being. The Youth Court, with its emphasis on identifying the underlying causes of offending, the use of a multidisciplinary team, its processes to encourage participation, bringing whānau into the process, giving victims a voice, is a court where those involved are seen, heard, understood, and are enabled to meaningfully participate. This is what is envisaged for the District Court. If you look at the graph of the figures relating to young people in the Youth Court and the dramatic and ongoing drop in numbers, it's the opposite of the graphs which would reflect the adult system over the same period of time. I would suggest that examination of the differences in process is justified. There are lessons to be learned. The approaches in the Youth Court have led to a significant decrease in numbers, which in turn has allowed for more intensive monitoring of the complex cases that do come to court. By building on best practice from the Youth Court, from Te Kote Rangatahi, from Pacifica Courts and the Young Adults Court, it is hoped that the District Court can achieve its vision. Seen, heard, understood, and been able to participate in the case which is about you ought not to be a big ask. When we say this in the communities, the general response is, isn't that what happens anyway? But we know that it doesn't. We've had decades of calls for transformative change in our criminal justice system because people do not have that experience. But we should all hold fast to these principles, which are essentially about fairness. Fairness in procedural terms, but also fairness in substantive terms, that is, fairness of outcome, which are outcomes informed by the court truly understanding the participants in the case and being able to fashion responses which fit those circumstances. Can I conclude by quoting from Judge Carly Truman from British Columbia, who said in 2002 in a judgment, the cognitively challenged are before our courts in unknown numbers. We prosecute them again and again and again. We sentence them again and again and again. We imprison them again and again and again, and they commit crimes again and again and again. We wonder why they do not change. The wonder of it all is that we do not change our expectations rather than trying to change them. Thank you for listening to me this afternoon. Nō reira, tēnā koutou, tēnā koutou katoa. So I'm happy to answer any questions, Alan.
Ngā mihi, Judge. Thank you very much. It's excellent. I've been tracking the questions as you've been speaking, and I nearly wondered if you were looking at the questions, because sometimes just as you rolled, I think you began to address some of them. But so I just made a few notes around that, and I really just want to just sort of reflect a little bit on some of the things you said at the same time. Just the power of the youth justice system as a whole. So it's diversionary, restorative and rehabilitative approach. And I think, and you gave us a lot of statistics, which were really good. And I think one that really resonates for me more recently is just that stark contrast when in New Zealand Aotearoa, we've raised the age to include 17-year-olds. We were a bit behind some other jurisdictions. And we saw where we had 7,000 17-year-olds in the adult court system, 44 in prison, within a very short time period, only a few hundred in the court system, and we have no 17-year-olds in the adult system, and seem to have seen a knock-on effect too, very few, if any, 18 and 19-year-olds in it. So I think it's the message and the evidence is really clear, and then just picking up on that other point, when we do have to have them before the courts, we know that the issues are often incredibly complex and it involves really serious offending. So I think it's the right balance. We need to be alert to both the opportunity and the risk about therapeutic jurisprudence, so that we get it right and the courts are able to do good, and we're open to avoiding doing any harm. And there was a question a bit later on about that, which I'll come to. I think that power of the interdisciplinary approach and that more intensive monitoring that you talked to is, there is a lot of evidence coming through about how powerful that is, the solution-focused judging, and especially when we know the high rates of neurodiversity, disabilities, the exposure to traumatic events such as family violence that you talked about. There was an interesting question from Mana Lawrence that asked about the incidences of adult mental illness in home and how that impacts on rangatahi. I think he was asking whether there was any statistics, but I just wonder whether you might want to talk to what your knowledge has been around that, because I know from my personal experience that, and you talked about a high call-out figure for family violence, I know that police probably attend even more instances around mental illness than that.
So I don't know whether there are statistics, but and there probably are. But my impression would be that if we are talking about circumstances where family harm is occurring, fetal alcohol spectrum disorder, talking about our young people, they're surrounded by addiction issues often, and they're in a familial situation which has also been affected in the past by the same sorts of issues and challenges which I'm detailing for the young people. So exposure to trauma, exposure to traumatic brain injury, and other neurodisabilities are likely to also be present in one or more of the parents. And so my expectation would be that the sorts of challenges which I'm talking about that affect the young people will equally be affect the family members in that household.
And it might well be something, and I've made a note that we need to have a look at how we might understand it more, so that we get a better understanding around that complexity. You talked about the challenges for us to address going forward around the inequitable outcomes for Māori and those that are disconnected from their culture. And, for me, it's so important about creating hope. And you clearly said, if you don't know who you are, how do you know who you want to be? How can you create hope? And so making the court process not only more understandable, which you talked to, but also how it can be more culturally appropriate. There was a couple of questions that have rolled through in that area, which I might just get you to comment on. One was around whether we should have the and you talked to communication assistants in the court. So do you want to just talk a bit more around that? I'll just quickly have a look at the exact question while you're doing that.
I saw the question.
Excellent.
Was there a need for more involvement of community assistance to be utilised more in the courts? And the problem is that there is a limited communication assistance workforce. It's not it's a finite number of people. And while we started using communication assistance in the youth court, a lot of other courts have now see the value of that and are also asking for assistance, not only for young defendants, but for young witnesses in the jury trial situation, both in the High Court and in District Court jury trials, equivalent to county court trials in Australia. And so there's an enormous pressure on communication assistance. I think what we need to be doing, where actually a communication assistant needs to be in the courtroom alongside the young person. But I would like to think that everybody in the courtroom becomes better educated about the communication difficulties which young people may be facing, and adapts the processes and the language in the courtroom so that they are able to have participation by young people without the specialist communication assistant necessarily being in the courtroom. So I think there needs to be a balance, but there's I know considerable work's been done by Talking Trouble and others, the communication assistant group, to educate social workers in particular, and police and judges. Everybody needs to be better educated about this, and I think that will take some of the pressure of the limited number of communication assistants who are available.
Thanks, Your Honour. I mean, yeah, Talking Trouble do a great job. So other things that obviously make the court more accessible is where it's culturally appropriate, and there was a question that talked about how we use more of law as an L-O-R-E in the court versus just the law, L-A-W, which was from Robert Baxter. I don't know whether you saw that question. Whether you did talk to the rangatahi courts as well. I'll just have a quick look to see. You might have found it quicker than me.
Yes, this is where we need our young people to understand and engage in the practice of law, L-O-R-E. This will hopefully lessen the offending and create better change to be mandated by the justice system. Use the law to enforce law. So certainly, this is largely reflective of where I hope we are heading with the overarching principles of Te Ao Manama, which is bringing the court process much closer to communities and iwi, area by area. Not every circumstance is the same, and moving our youth court onto marae for Te Koti Rangatahi is a really, really good example of making the court process relevant to the community which is being served. And I know that the theme of this conference is about youth justice for the community, by the community. What that means is that the court can no longer be sitting as something separate and apart as an institution, somewhere where nobody really has any connection with. The authority for judges to exercise their power comes from the communities that they serve. It's not just as a result of some piece of paper on a warrant saying you've been appointed a judge. The legitimacy of the courts relies on the institution being seen as part of and relevant to communities, and that means all components of communities. And so Te Koti Rangatahi is primarily bringing the court into its community in a really obvious, physical, visible way, and the difference in that setting, the way in which the law is the respect for the process is greater than in this sterile institution, which has grown up to be separate from the communities that it serves, which is the barrier that we need to break down.
That's excellent.
I should say that I was at a swearing-in ceremony yesterday for a new judge, which started with full pulwhiri, and each of the speeches in the ceremony by the lawyers was commenced in Te Reo Māori. Waiata was sung, and it was as an example of how law has come into the law.
That's excellent, and I'm just aware of the time. We've got 5 minutes to go. There was a couple of other questions in the same vein, which we can look at afterwards, and great to see that level of interest. There's another question here from Casey Tyler, thanking you, Judge, and that the panel will be reflecting on access to justice issues for children with disabilities this afternoon. And this was a fantastic introduction. Thank you, Olia. I thought that might have... And that looks like we've covered most of the questions that are in there. I understand definitely quite a bit of interest in how you mainstream it, notwithstanding age. And there's a specific question there from an anonymous submitter that is wondering about how the rangatahi and Pacific Court processes might be done for the young people's list that you're managing.
I should say about that may very well end up to be a development of a young adults court, particularly where we have plans being monitored. We also have a lot of diversion happening from the young adults court onto iwi panels as a diversionary method, but I can see no reason why in appropriate cases a plan which has been monitored in court might be monitored on marae, exactly as what happens with Te Kote Rangatahi, which is the monitoring of a family group conference plan. So the court could always change its venue. It doesn't need to sit in a court building if it's more appropriate to sit somewhere else.
Excellent. And there's quite a bit of, I wonder when I look at some of the questions whether we should think about how we make a link to the speech notes from the Chief District Court Judge around Te Ao Marama that you referenced as well, because I think that they would go to address. We are running out of time, and we're now going to look to be moving to see a presentation from our young people from a program in Kapiti and from the Youth Justice residents in Te Punawai in Christchurch. But again, Your Honour, thank you very much for the presentation, making yourself available today. You could see, obviously, from the questions, a lot of interest, and it's really neat to see how, because I did read a book many years ago, it isn't happy birthday and goodbye at 18. You're seeing how all the progress that has been made in the youth justice system can also be transferred into the adult system. It's incredibly exciting, and I just want to thank you again for that work that you're doing as well as your presentation today.
Thank you very much, and a great pleasure. All the best for the rest of the conference, everybody.